Hello, everyone. Sufit here. I'm here today with our guest, Charles B. Ticker, estate mediator and litigator. We're here because November has been designated by the Ontario Bar Association as Make a Will Month. Make a Will Month. So we can expect a lot of media about how people don't make wills, 50%, 80, like I don't know what the numbers are, doesn't matter. A lot of people don't make a will. And those who do don't always use a lawyer. So you're going to see a lot of media about that. What you're not going to see a lot of media about is what we're going to discuss today with our guests. The idea that even if you do make a will and even if you do see a lawyer, there still could be a problem. And that is that if you have more than one child, more than one adult child, sibling beneficiaries, if you leave it to them all equally, you think you're being fair, right? You think that the only problem is going to be if you leave it unequally. Well, our guest today, Mr. Ticker, is here to tell us that that may not necessarily be so. Charles, take it away.
Thank you very much. That's correct. A lot of people think, well, what can be unfair about equal division of assets in the will? Well, equal doesn't mean equitable necessarily, and we do see this quite often in reported court cases and in my mediation practice. And one example, and quite often involves the family farm for some reason. There's been a lot of farm cases on this point. Is one of the kids works the farm during their lifetime, not getting paid much and working long hours with the promise by the parent, yeah, we know you're doing more than your siblings. One day this farm is going to be yours. And the parent sometimes forgets that promise or doesn't really think it was a promise. And they make a will leaving the farm to, let's say, their two kids equally. Well, the child that was promised the farm is not going to think that this equal gift is fair. And there was actually an actual case that I wrote about in my book, Bobby Gets Bupkis, about the Mountain family, where the son Gary was promised a family farm, and that promise didn't appear in the will. It wasn't carried through by the parents. So he took his sister to court saying, I was promised the farm. Now, there's some intricacies in Ontario law and in other jurisdictions as well, that when you're suing for an interest in land, it usually has to be like pursuant to a written agreement or some sort of document. There are exceptions to that. Anyway, in this case, it was a verbal agreement. It wasn't reduced to writing, and the trial judge said, sorry, I think this is after the dispute had been going on for about 9-10 years. Sorry, son, you lose the case. Well, went to the Court of Appeal, and the Court of Appeal said, no, we don't agree with the trial judge. There was evidence that could establish this promise. But the Court of Appeal said, instead of having another trial, they did something, which I think is great. They said the parties got to try to go to mediation first before they go back to court. So that's what they did. They went to mediation, and guess what?
Did it work?
Yeah, they settled at mediation.
All right.
One problem. They couldn't agree on what they agreed on. So they went back to court to interpret what their settlement agreement was. So, and that happens sometimes, even after a case is supposedly settled at mediation. So not only do wills have to be carefully drafted, but settlement agreements or minutes of settlement have to be very carefully drafted and thought through at mediation, so everybody knows what the deal is. So that case went on for 14 years. And eventually, I think the son was ordered to pay $1 million and change to his sister, but nobody knows the hundreds of thousands of dollars in legal costs that was spent in that case over the 14 years.
Wow.
So just a very sad situation because the promise wasn't kept. So there's an equal division of the will, but there's a promise outside the will, and that sort of creates a problem.
And before we continue, I just want to remind our listeners that, or our viewers, that today is the fourth. Today's video is the fourth in a series of 4 videos for November Make a Will month. This is the fourth one, and in every video, Charles has shared with us a couple of scenarios where equal is not necessarily considered to be fair by the beneficiaries who are siblings. So the scenario you just described, maybe we'll call it broken promises. And today, to wrap it up, we're going to have two more scenarios where equal may not be considered to be fair. So, Charles, what's the next situation?
Well, another situation that we see is, excuse me, let's say there's 4 children and they're all left an equal share of the estate, so, as beneficiaries, but the eldest child is chosen as the executor. And so there may be some resentment amongst the other children that they weren't appointed to be in charge of the estate administration. And there's a resentment if that sibling who's the executor has the gall to ask for compensation for all the work he or she is doing as executor. Family members shouldn't charge executor compensation. Well, of course, they're entitled to it, but there's resentment there. So what some parents do they think to avoid that situation, they say, well, we got 4 kids, let's make them all executors. Nobody complain. Well, that's another recipe for disaster, particularly if the parents know that the kids don't get along. Because if you have 4 executors, the law says they have to be unanimous, or you have or there's a stalemate. You can't go further unless you have a majority clause. But if you had 4 executors, let's say it's 2 versus 2, now you got a stalemate. So, I always said too many cooks spoil the broth. So, making all the kids equal as executors and beneficiaries is not always the best choice,
Well,
depending.
sounds like you can't win on that one. So what do? Do you appoint the one that you think would make the best executor and cause siblings to be resentful, or do you make it equal and do all 4 and let them battle it out to the death? What do you do?
Well, if sometimes what you'll see in wills is somebody will be brought in as a tiebreaker. It might be an outside family advisor, a lawyer, or an accountant, or maybe name that person, try to find someone outside the family to be an executor. The point is, when people are making their wills, they don't always give enough thought as to who the best person is for the job. And a lot of families say, well, we'll go with our eldest. Well, the eldest may not be the best person. You want someone who has the proper skill set to be an executor, someone who's good at record keeping, someone who's good with numbers, someone who can work with professional advisors. So, people have to give more thought when they're drafting their will as to who their executor should be. And that may trump, whether or not all children have to be treated equally to be executors.
Is this something that you would recommend should be discussed ahead of time with one's children when making a will? Like, do you want to be an executor? Is that something that should be done?
Well, I think that's an excellent idea, or talk about it at the time the will is being done, or just after it's done. Because another thing is, someone who's appointed as an executor, when the parent dies, they don't have to take on the job; they can renounce. So you may not get the person you thought you were going to get. So definitely, anytime you got someone in mind to be an executor of your estate, good idea to run it by them first, because they might say thank you, but no thanks. Because it's a very difficult job, and it's quite often a thankless job.
Okay, well, so take us home here, Charles. We have one more scenario we're going to share during Make a Will month. One more scenario where equal may not be deemed to be fair.
Yeah, I'd like to call this one the Beverley Hillbillies scenario. Remember I might be dating myself, but there used to be this show on called the Beverley Hillbillies I don't know if it was in the 60s or 70s, about
tell you a story about a man named Jed.
Jed Clampett, and they were hillbillies, but they struck oil and they made a fortune, and they moved to Beverly Hills and they moved into this big mansion, but they were still living as hillbillies. But can you imagine, let's say, you have that situation where you're living, out in the hills in poverty, and you got 4 kids, and the first 2 kids grow up in poverty, and then one day, you're shooting at some food, and out comes the ground with a bubbling crude, Texas gold, and all of a sudden your life changes and you're gazillionaire. And now the younger 2 kids are getting the benefit of the better schools and the music lessons and the summer camps and the big mansions. And the other two kids who are older, they're already, they didn't experience that. So you have a situation where they're left all this money equally in the will, but the two older children may resent the fact that they had it harder as kids, and maybe they should get a little more because their other siblings had it really easy. So not a common scenario, but it's one that I wrote about that was based on an article that I read, that seems to suggest that this is another area where equal may not be perceived as fair.
No, you say it's not a common scenario, Charles, but I can think of at least two real life circumstances right away of stories that I've been told. I don't think it's that uncommon, actually, because people do have changing family circumstances. One maybe gets, a big lavish wedding, and then the next one, they drive through Denny's.
Exactly. That could happen. Let's say if there's been a change in financial circumstances, so the parents can't help with the second wedding. Look, I know just in my own family situation, I have two daughters. I remember they were growing up, and the first daughter got the new bike, and the second daughter got the hand-me-down because
Right,
there was nothing wrong with the old bike because the
right.
first daughter, my eldest daughter, hardly rode it, right? So, but there was always that resentment. I got the hand-me-down. I didn't get the new bike, I
I'm
guess
not going to
it.
put you on the spot and ask you if you're going to leave her a little something extra in the will.
No, I'm going to spend it all.
Good for you. Our guest today has been Charles B. Ticker, estate mediator and litigator. We're here with this series of 4 videos in relation to the Ontario Bar Association Make a Will Month. Thank you very much, Charles.
My pleasure.